Welcome to Thursfields Talk Legal, a vidcast series from one of the leading law firms in the Midlands. I'm Steve Dyson, a journalist who's talking to a range of solicitors at Thursfields on legal topics of wide interest to the public and businesses. Today's episode is called What to Expect When You're Not Expecting, a Clear Guide to a Dispute. Joining me online to discuss this is Stephen Rome, a director in the Dispute Resolution Department here at Thursfields. Hello to you, Stephen.
Good morning, Steve. Thanks very much for inviting me back.
No problems at all. Stephen, most people are understandably reluctant about involving the law when they have a dispute. It's an uncomfortable situation, isn't it, which no one really wants. And for most people, taking legal action is not something they're even familiar with. With that in mind, Stephen, what are the alternatives to going to court?
Yeah, well, I'd say the cheapest and quickest route is to explain to the other party what the problem is, what the complaint is all about, why it's an issue, and what you want them to do about it. They might not want to do anything, and that's probably the situation where you end up having to come to speak to a solicitor about the problem. And at that first meeting, what the solicitor will go through with you is what the problem is. They'll seek to explore and get more further information about you and sort of generally give you some guidance and advice as to what can be done to resolve the situation, what your legal rights are, potential defences that the individual or the other party may have to the claim that you're going to be putting forward, and then also ascertain what your objectives are. Are you looking to get compensation or some damages? Are you looking to get some property back? So there can be all sorts of ways of solving this problem, and that's sort of that first task at the initial meeting with the solicitor is to go through with you with that. And most importantly, of course, is also the costs and what and how much time it may take to get you there.
That all makes sense, and for anyone to understand their own legal issue or rights, taking the problem to a solicitor can obviously help them to simplify what's what and what's possible. Once you've done that, what are the next steps?
So what the solicitor will then write to the other party, or alternatively to their solicitor if they're already represented, and set out essentially what the claim is. It's called a letter before action, and it's say, this is what has occurred. It might be something like a breach of contract, what the damages are from that breach, and what they want the party to do, and what happens if they don't do it, as in, what steps will be taken next. Typically, what you'll then get in response is a reply, say, from the other side solicitors, and it's there to sort of set out what they accept in the claim that's been put forward in that first letter, what they disagree with and why, and really it's an attempt to sort of narrow the issues. And that then also presents usually the first opportunity to avoid having to go to court. And it may be that one of the parties proposes some form of alternative dispute resolution. And perhaps one of the most popular methods is mediation. And mediation is where you engage with a mediator who is a neutral party trained in seeking to achieve resolution between two parties that are in dispute. And it will typically be conducted at maybe your solicitor's office or the other side solicitor's office. And it will be a day where you will have a joint session with both parties in the room and the mediator, setting out essentially what they're looking to achieve that day. And then for the mediator to spend the day shuttling between the rooms. Now, in the past year, a lot of that sort of face-to-face mediation has gone out the window with the current pandemic. So it's actually been taking place over Zoom or Microsoft Teams, which still can be very effective in achieving resolution of the dispute and having to go to court. And there are other alternatives to mediation, for example, what we call without prejudice meetings. So it could be that with the client and the opposing party and their solicitor, you have a day trying to talk through the issues again, trying to reach some resolution. That can be cheaper because there's no cost of the mediator there. But equally, it sometimes can be less effective because parties tend to get quite entrenched in their positions, and trying to get through those difficulties can be hard when you don't have a neutral party there. And then another alternative is something like expert determination, where the parties have agreed that someone like an accountant, for example, will resolve the dispute. And this is typically used where there's some form of share purchase agreements where there's some form of earn-out, and the mechanism for calculating how much money can't be agreed, so they hand it over to an expert to then make that determination. So those are all alternative methods that are avoiding having to go to court.
That's all sound advice, Stephen. And I guess the sense in taking this pre-court action, if possible, is to get things agreed without it all costing a fortune.
That's absolutely right, Steve. That before you make that step to go into court proceedings, you would already have spent some money in looking at these alternative methods of dispute resolution. And as a general step, could be between £5,000 and £10,000. And then on top of that, it's the money as well, time as well as the money. That from that first meeting that you've got with your solicitor, you could be talking about 2 to 3 months where you're sitting in a mediation room looking to resolve the dispute on that day. So the costs at this point are actually quite small in comparison to what will later be the costs and the time involved were this to go to court.
Understood. But what if there's been no settlement, Stephen? No agreement, and you're getting nowhere fast with these alternative methods?
Okay, so there's been no settlement, no agreement, and it's looking then at the next step of what you will need to do to resolve your dispute. So that first step is starting the legal proceedings through the court process. And that begins with 2 documents, the claim form and the particulars of claim. And these essentially set out the legal elements of your claim. And your solicitor will work with you to put together the facts of your particular situation and combine these with the legal requirements needed to prove your case, whether it involves breach of contract or some form of negligence or even fraud. Most importantly, it will reference what you are asking a court to order the other party to pay. So could be, for example, your damages. Now, that's important because that is connected to the court fee and how much that you'll be required to actually start your claim. So, for example, the highest value claims have a maximum court fee of £10,000. So if your claim's in the millions, you've got to put up quite a chunky amount of money up front to start proceedings. Obviously, lower value claims have a smaller court fee. So once you've got your claim form, particulars of claim, your court fee, and these are sent to the court, they're processed, and typically the court will then serve the other party. So this is where the documents are sent, typically through the post, and then received by the other party. There are certain rules on what is required in relation to service, because you need to follow those rules to avoid any subsequent judgment that being set aside. So once the other party has received those court papers, they typically have 14 days to acknowledge, and that's where they have the opportunity to say whether or not they accept that the court has what's called the jurisdiction to hear the claim. And then once they've acknowledged the proceedings, they then have a further 14 days, but they can request longer, to ask to prepare the defence to the claim. And this is going to be setting out what they disagree with in the particulars, why you may not necessarily have satisfied the test. It also is the opportunity that, for example, if they've not been paid some money that they think they're still entitled to, they will bring what's called a counterclaim. And a scenario might be that, I don't know, you have asked a builder to carry out some work on your property, and you agreed to pay them £10,000. By the time they have completed that work, there's a balance of, say, £2,000 outstanding, but the work that's been carried out is defective. No, the roof's still leaking. So you're bringing a claim for the value of rectifying that work, but the builder may be saying there's nothing wrong with the work that they've carried out, and they'll be seeking a counterclaim for the £2,000. Once that defence has been filed, then the court will send out case management questionnaires, and this is asking the parties to provide information about their claim so that the court can allocate it to one of the 3 tracks. So, for example, it's a high-value case, which is quite complex. You would have started those proceedings in the High Court, and you're likely to see that that is a claim that's suitable for what's called the multi-track, where you may have several witnesses, so you're going to need more than a day in court. You may have an expert being required to also give evidence, and there may be a large number of documentation. And then sort of going down sort of the various other alternatives, you may find that your case is a lower value, say £100,000, suitable to be dealt with in the county court, and may only need to take a day of the court's time, and that may get allocated to the fast track. And then at the sort of the opposite end of the complex claims is something that most people are familiar with, which is called the small claims track. And this is something that this would be suitable, say, for a claim that's worth £10,000 or less, maybe just a couple of witnesses. It might take 2 to 4 hours for the court to make a decision. And the difference is quite stark, because on the small claims track, you tend to have what are called fixed costs. So the court fixes how much parties will get paid if they are successful in their claim, whereas at the opposite end, the fixed costs are not going to be used, and that's where you're talking about a much higher amount of money owed. After you've gone through that case management and an initial first hearing, which is where the directions to trial are given, and this could be where, for example, you have to provide disclosure of documents that support your case or undermine your case. You have to get witness statements from people that can actually comment on what happened at the time. And then at the end of all of this, you have the trial itself. That can be quite a nerve-wracking occasion for someone that's never been involved in court proceedings before. They may have to give witness evidence. They will be cross-examined by a barrister. It can be a very difficult and challenging day. But it's that opportunity for a judge to hear your dispute, why you feel grieved by the situation that you've been placed in. And once the judge has reviewed the documents, has listened to the witnesses, has heard from any expert, he or she will then be in the best position to make a decision on the case and whether a judgment should be given in your favour, and ultimately you get your damages and a proportion of your costs in pursuing the claim.
Just listening to you, Stephen, I can almost hear both the clock ticking and the calculators tapping. Going to court is going to cost a lot more money, isn't it?
Yes, that's unfortunately that's true. That those types of claims that I mentioned that are particularly complex, you could be talking about £100,000, well over £100,000 in legal costs for multiple days in court, for your legal team to be there presenting your case, and hundreds of hours of preparation time in reviewing the documents, reviewing the witnesses, and working with the experts in teasing out the issues. And alongside that sort of figure, 6 figures of legal costs, you've got the time. So I mentioned earlier about potentially 3 months to get to a mediation. A court case could take sort of another 12 months to 18 months, depending on the amount of time you need in the court's diary and the availability of witnesses. So it's a much longer process and costs a lot more than that first situation I mentioned about mediation. So you really need to decide at the early stages of any proceeding, is it worth going after this? Is the defendant going to be good for that money as well? And are you going to be able to recover these costs? So all important factors to keep in mind.
Assuming the case is successful, though, Stephen, I guess the next stage is collecting your damages.
Yes, but it's not necessarily as simple as that. So you've got your judgment, which is a piece of paper saying that the other party owes you a certain amount of money as well as costs. So you've got to then move towards the options that are available for enforcement of that, assuming that they don't automatically pay up the following day of trial. Some of the ways to enforce a judgment can be, for example, what's called a charging order. So this is where the judgment debt is secured against the property of the other party. So, for example, if they own a house, you may secure it against their interest in that house. And then when it is sold, you could be that's the point where you'll get your money back. The other methods of enforcement could be entering the property, so a court bailiff being appointed, and they will enter the property and remove goods. They're later sold, and that money is then used to pay the debt. Something called a third-party debt order. So this is where you may have details of the bank accounts of the other party who is meant to pay you money, and you can make an application to court to get the bank to pay the money, or at least freeze the money in that account, so that it can be paid to you at a later date after a hearing. So these are all options to get what you're owed. Obviously, there are further costs and further time in going down this path. Ultimately, at the end of this, if all of the other methods fail, you have to look at the insolvency option. So this could be putting a company into some form of liquidation, or putting an individual into bankruptcy. And whilst this is the most drastic method possible, it doesn't necessarily lead to recovery of all of your costs. But certainly it's a way of, if the party is refusing to pay, it will force their hand in making them pay, to avoid that situation of being put into some form of insolvency.
I understand. Stephen, what about if the person or business that's lost the case against you, what about if they disagree? How do they appeal? Can they appeal?
Yes. If they disagree, what they can look to do is appeal. And this is sort of an opportunity for them to go to a higher court and say that the judge's reasons for giving judgment against them were wrong. It's very difficult to say, for example, if the judgment was based on the facts, to say that the judge got it wrong. But it may be that they have misdirected themselves in the law, and that would be a reason to pursue the appeal. But the steps to go down that is that at trial, after judgment has been given, you should be asking for permission to appeal at that point, and the judge typically won't give permission to appeal. It's very strange for a judge to sort of admit that they've got it wrong, but it does sometimes happen. But if permission isn't given by the judge who heard your case, then you seek permission from, if it's in the High Court, you'd go to the Court of Appeal, and a single lady or Lord Justice will review the grounds on which you say that permission should be given. And then if they agree with that, then permission's given, and then it will lead to another hearing in the Court of Appeal. Again, you're talking, could be several months before you even get to the point of that hearing. And again, could be sort of tens, if not hundreds of thousands of pounds to pursue the appeal. And there are appeals against appeals. So the Supreme Court ultimately will hear the final appeal. And so there are cases which have gone all the way to the Supreme Court, taken several years, and could be in the millions of pounds in terms of legal spend. And the court's decision in the Supreme Court will ultimately settle the whole dispute. And one party is going to be left the victor, and the other party is left with quite a large bill, as well as potentially any other damages that were originally claimed several years ago.
Wow, it's fascinating stuff, Stephen. And you've made it very clear what the three stages are: pre-action, court action, and post-judgment processes. It's a lot to take in, so perhaps you can give us a brief few top tips for businesses who might be considering legal action.
Sure. I think, first of all, I would say be prepared. So sorting out disputes can be long and tiring, and there will be difficulties throughout with many ups and downs. It can be very much an emotional roller coaster. And worst of all, it's detracting from what that business owner is trying to do. They're trying to establish their business, and the litigation is usually a side part of what they do in their day-to-day job. The other top tip I would say is talk to your solicitor. Communicate with us as early as possible, because there are so many challenges in the way when we are approached at a much later stage, and there may be points that have been missed. I would say also be very upfront and open with them. The whole purpose of this exercise is for you to tell them everything, warts and all, because if you don't tell the solicitor, then it's likely that the other side solicitor will know that, and that could be used to undermine your case. Whereas if we've been armed with everything, even the nasty stuff, then at least we can sort of take that into account when we're formulating how best to proceed with the claim. And also, probably most important is just have that end goal in mind of what you're trying to achieve. You know, what were those first objectives, and use that to keep in mind sort of the importance of the proceedings as you're going through.
That's really useful stuff. Stephen Rome, a director in the Dispute Resolution Department here at Thursfields. Many thanks for joining us on Thursfields Talk Legal.
Thank you very much for having me, Steve.
Hopefully what Stephen had to say is something businesses will find useful. If anyone wants any further advice, Stephen is available on 0121 726 8782 or on email at srome, that's SROME, at thursfields.co.uk. We'll be back soon to talk to more legal experts here at Thursfields about other interesting aspects of the legal world. Thursfields Talk Legal. Thanks for listening.